All right, let's talk about what we call sources of the law. Okay, there's a difference between what we call primary sources of the law and secondary sources. Okay, primary sources are the law itself. Okay, so let's talk about what those are. Obviously, the Constitution of the United States and the state constitutions, statutes that are passed by both the federal legislature, Congress, and the state legislature up in Sacramento. Court rules that are normally basically made up by the judges, and then the legislature kind of stamps them and gives them the okay to, like the Supreme Court of the state of California generally writes all the court rules, and then the legislature just kind of lets them do their own thing, but the legislature can, invalidate or not pass a law if they don't think it's necessarily appropriate for a court rule. Administrative regulations, I don't want to get into administrative agencies now, but basically how that works is Congress creates a big law. They want more laws, and they don't have time to write every law. And so they delegate that authority to an administrative agency like the Environmental Protection Agency, OSHA, whatever it might be. And then the administrative agency writes the laws. And if Congress doesn't like them, they can change them and make their own law. And then the administrative agencies are actually run by the and enforced by the legislative branch. Okay. The last set of laws is we've already talked about cases that interpret statutes and the Constitution and the common law. Okay. Cases where the judges made up their own law. Those are examples of primary sources. Okay. Secondary sources explain the law. Okay. Most of the time when we do legal research, we don't just start looking at primary law. Okay. We want to get an overview of the law and get an explanation of the law by a legal expert. Okay, so these include what we call treatises, which are written by generally law professors and legal experts. Law review articles, which are written by law professors and law students. Legal periodicals, law dictionaries like Black's Law Dictionary, and continuing legal education publications and things like that. Okay, in California, we're going to talk about a lot of secondary resources later that are excellent. California probably has the best secondary resources of any state. And we'll see that normally we want to start our research by looking at secondary sources and not by the law itself. It's easier to have somebody explain the law to us than it is to just go read the law itself. Okay. All right. So also there are things like what we call restatements, horn books, legal encyclopedias. Okay, and we have some really good ones here in California. So those are examples of secondary sources. The big difference is secondary sources are not the law. They just explain the law. So generally, you cannot use secondary sources as what we call legal authority when you're presenting the law before a judge. But we'll get into that more later. Okay. The last topic in the chapter is called citation. When we put law before a judge, even though the judge has knows that what we're saying is the law, that's not good enough. We have to cite the law. And what we mean by citation is we need to provide a reference. This is like, when you do a research paper and you have footnotes to where you got your information. It's the same kind of thing. What we have to do is we have to give the judge a citation to the legal authority so he can go to the law library, or these days more likely online, and actually look the material up and read it for himself. So if we're citing a particular case, we have to tell him where we find it. If we're citing a particular law, we need to tell him where we can find it. And we have to do that in the proper format. Okay, judges can be very anal, okay, we'll just say anal, about legal citations, particularly in federal court and especially in the appellate courts, okay, that you have to get the citations right. But we'll work on that later. Okay, so normally we want to cite primary authority to judges. Okay, we can cite secondary authority if there's no primary authority on point. Particularly, it's a new issue in the state, and other states have decided that we could cite maybe that. But we'll get into that later in the course. Okay. The last topic in the chapter is legal publishing. Okay. Now, with legal publishing, there's basically two big dogs out there in the legal world. Okay. There's Westlaw and there's LexisNexis, which was bought out by I think it's Reed Publishing or what do they call them now? Yeah, Reed Elsevier, I don't even know. Okay, but we just know them as basically LexisNexis and Westlaw. Okay, and they compete against each other. And as we'll find out later in the course, sometimes you're going to find things in Westlaw that you're not going to find in other publications like the LexisNexis publications. And for most of the country, you can get away with just West publications and Westlaw type stuff. In California, that's not necessarily true, because in California, we've got some really, really good secondary materials that are not published by West. They're published by Matthew Bender and some of the other things. So we'll get into that, the detail of that later. This is generally just meant to provide an overview and let you know that there are two big legal research publishers out there, and they're always competing against each other. And if you can't find something in one publisher, you might be able to find it in the other publisher's materials. Okay, so that's it regarding the chapter. I'm now going to do a little spiel on the assignments for this week. The two chat room assignments you have this week, you can find the actual questions on page 14 of your text. They're questions 1 and 3. Okay, 1 has to do with the advantages of the common law over the civil law. Okay, I'll leave it up to you to speculate and contribute on what you think those are. Okay, that's the point of the learning exercise. The other one I want to get into is number 3, which has to do with the Senate's role in the judicial process. And I didn't get into this earlier in the checks and balances. I probably should have, but I'll just deal with it here. Okay, one of the checks and balances in the judicial system that involves all 3 of the branches is the nomination process for federal judges. Okay, now this is really important because federal judges are appointed for life. Okay, you cannot remove them, and in fact, you know, some members of the court have sat into their 90s. Okay, Supreme Court justices literally sit on the bench till they die. But all federal judges, if they're appointed by the president under Article what we call Article 3 judges, they sit for life, and they can only be removed for things like incompetence or, you know, scandal or something like that. Okay, they can't be removed because the Congress is pissed at the decision they made. Okay, so there's a big fight on the nomination process, and this is the way it works. The president gets to nominate federal judges, but they must be approved by the Senate. Okay, whether it's a Supreme Court judge or a district judge sitting up in Fresno, they have to be nominated by the president and approved by the Senate. Okay, and when the Senate and the Senate and the president are from the same political party, it usually isn't that big of a problem. Okay, but when they're from different parties, okay, let's say we've got a Democratic president or a Republican Senate, which we've had in the past lately. The Senate doesn't want Obama, or I mean, it could be anybody, or Clinton, to get his liberal justices on the court, okay? Because the court, these judges are going to live long past or be on the bench long past these politicians are going to be around. Okay, so there's always a big battle on how, you know, who's going to get nominated. And obviously Republicans don't want liberals, and Democrats don't want conservatives, okay? It's happened in the past when President Reagan nominated Judge Bork, who I think some of his decisions are absolutely horrible, but his qualifications for being a Supreme Court justice were absolutely there. And so there can be these fights about how and who should be on there. Most recently, what's happened is there have been senators, because the Democrats control both the Senate and the presidency right now. the certain senators have threatened to filibuster some of Justice or President Obama's judicial appointments, and they, there's debate over whether filibuster is a proper use of judicial nominations or not versus a general law, or whether this is appropriate. And most of the time, they worked it out by some type of settlement where the Republicans have gotten something in return for Obama getting his nominations through. I'm just using Obama right now because he's the president. It's happened when we've had Republicans, like I said, like Reagan, and a Democratic Senate as well. Okay, so one of the things I want you to consider on the chat this week, or the online discussion forum, is some have accused the Senate of unduly delaying the confirmation of federal judges. Is that a fair accusation or not? Do you think this is going on? Do you think the Senate is overstepping their bounds in that regard? I don't want to give you my particular take on that right now because I don't want to influence the discussion. I certainly will reveal my opinion about that later on. Remember, it's only my opinion, and differing view. We can certainly have differing views on that. Okay, but I want you to try to have a good discussion on this point about whether you think the Senate really is overstepping their bounds or not. The debate should be something. Should the Senate just look at the qualifications? Or do you think the Senate should look at the political leanings of the particular candidates? Okay, this happened when the Senate was controlled by the Democrats, and Bush was appointing people like Roberts and Alito. Okay, and so those are the issues I want you to discuss. I'm here to talk to you. If you want to email me, let me know. If you want to talk in person, let me know. And we'll get going. Hopefully this will be a very rewarding class for you. And do your work this week. We'll have a written assignment due next week on Chapter 1. Won't be too difficult. Won't be too long. And, look forward to seeing you next week on Chapter 2. Have a great day.